It has been a year since Chief Executive J.P. Gallagher turned against LGBTQ2+ by stopping one of its own from talking at the library. But I feel the need to back up and show what started all this. Under HB 359 that prohibits drag performers from leading story hours in schools and libraries, which is unconstitutional. This is content and viewpoint-based restriction on free speech. But that's not all. The bill bans reading to a child in a library in a superhero costume, conducting classroom activities dressed as Ms. Frizzle, inviting a Disney princess impersonator into the classroom, and staging a production of Shakespeare's As You Like It. These restrictions apply regardless of a person's gender identity and sex. Additionally, HB 359 limits First Amendment activities of artists, businesses, and entities that receive state funds. Displaying or disseminating obscene materials and performances has long been illegal in Montana. MCA 45-8-201. HB 359 creates new, confusing restrictions on sexually oriented performances with a definition that allows the display of human cleavage but not prosthetic cleavage, restricts stripping regardless of whether nudity results, and may, this is unclear, prevent allowing minors to view any simulation of sexual activity, salacious dancing, or any lewd or lascivious depiction or description of human genitals. Unlike the pre-existing obscenity statute, HB 359 does not incorporate the Miller test, the classic definition of obscenity, which safeguards artistic expression, political speech, and science. Worse still, an entity that receives any state funds, i.e., any art museum or independent theater, cannot display a live or pre-recorded performance with essentially any sexual content, regardless of artistic merit, and even if the audience is limited to adults. HB 359's penalty provisions are as confusing as they are draconian. Everyone involved in putting on a drag, story hour, or so-called sexually oriented performance can be sued within 10 years of the event by a minor who attends the performance, even if the minor and their guardian consented at the time, with statutory damages and attorney's fees assured to the plaintiff. If the person who violates HB 359 is a library, school, teacher, school or library administrator, entity that receives any form of funding from the state, or employee of such an entity, they shall be fined $5,000. Moreover, teachers and other school personnel will be suspended for a year. Upon a second offense, they will lose their certificates. And if the violator is a business that serves alcohol, it will be fined between $1,000 and $10,000 per violation and ultimately lose its business license. HB 359 is Frankenstein's monster that manages to pull together the worst of prior versions of the bill and incorporate all of the constitutional problems and drag bans recently struck down elsewhere. HB 359 is calculated to target the LGBTQ+ community, but the bill overshoots this sinister mark. HB 359 threatens teachers, artists, small businesses, and cultural and scientific institutions with criminal and professional sanctions. In court documents recently obtained show that Gallagher does not understand the First Amendment of the Constitution or the oath of office he had taken twice. In court documents, Jort says Gallagher decided to cancel Plaintiff Jewort's lecture at the Butte Silver Bow Library. Gallagher admits that he, in consultation with the BSB County Attorney, decided to cancel a lecture to be given by Jort at the BSB Public Library scheduled for June 2, 2023, because of concerns that the lecture could violate Montana law. Gallagher admits that the First Amendment of the United States Constitution, in part, prohibits laws that abridges the freedom of speech. Gallagher denies that he, or BSB, enacted any law abridging Plaintiff Jewort's freedom of speech. Through her lecture at the Butte Silver Bow Public Library, Jort, by speaking at the library, intended to engage in a constitutionally protected activity. Gallagher lacks sufficient knowledge or information regarding the allegations of Plaintiff Jewort's intentions related to her lecture at the BSB Library. In canceling Jewort's speech, defendant Gallagher intended to, and in fact, did suppress Jewort's protected speech, denying her the opportunity to speak and denying the audience the opportunity to listen. Gallagher denies that in canceling Plaintiff Jewart's talk at the BSB library he, or BSB, intended to suppress or did in fact suppress Plaintiff Jewart's protected speech. Gallagher affirmatively states he attempted to resolve the issue with Plaintiff Jewart in a manner that would legally permit her to present her scheduled talk at the BSB library, but Plaintiff Jewart declined to speak with Gallagher to reach such a solution. Defendant Gallagher's cancellation of Jewart's speech was motivated by the content of her protected speech, in violation of the First Amendment. Gallagher denies that BSB's decision to cancel Plaintiff Jewart's lecture was motivated by the content of her speech and affirmatively states that neither he nor BSB violated Plaintiff Jewart's constitutional rights under the First Amendment of the United States Constitution. To the contrary, Gallagher attempted to resolve the issue with Plaintiff Jewart in a manner that would legally permit her to present her scheduled talk at the BSB library, but Plaintiff Jewart declined to speak with Gallagher to reach such a solution. As some of you are aware, Jewart did not have to speak with Gallagher because he already violated her rights by canceling the event, and there is no way to make that right. Gallagher has already spent over $10,000 of our tax dollars on this case so far, and it's far from over. Thanks for watching. Please like, share, and subscribe.
Is put, Ms. Jewart, please be advised that the decision to cancel your appearance at the Butte Silver Bow Library on June 2nd was based on a Twitter post stating, "And I will definitely have a book, and sexuality will be discussed, and minors may be present." I do, as an LGBTQ Two-Spirit history lecture at the library June 2nd. I'm really entertaining at this one too, but this literally might be illegal in Montana as a flamboyantly dressed trans woman. Analyzing the language of the provisions of House Bill 359, Butte Silver Bowl made the decision out of an abundance of caution to cancel your appearance at this time.